about 35 candidates have been already in the pipeline of working in different IP firms. We are very glad for that. So these are some of the services which has been offered at KCST, and uh, I think we'll directly move to the subject part, that is the startups related to what are the facilities that has been from the government and the private agencies or whatever it is. Okay, and I'm glad to tell you that because of all these kind of services which KCA has been providing in 2022 last year, we have been awarded with the Special Citation Award at National IP Awards 2022 from the Honorable Minister, and this is one of the greatest achievement we can say. And we have been moving ahead to achieve more this kind of success. And now I request Dr. Sarasija Padmanabhan to kindly just introduce the participants regarding the major benefits of this particular session. I request Mr. Shivling to kindly introduce Madam to the audience.
Sure, definitely. Welcome, madam. And talk about Ms. Sarasija Padmanabhan. She is currently a patent agent at KSCST and a tutor at WIPO, stands for World Intellectual Property Organization. She is a proficient, patent facilitating expert with approximately 20 plus years of experience. She is actively engaged for a long time now in promoting IPRs, awareness, scientific research, and innovations with KCST. She specialized in area of organic chemistry and biochemistry and other elite subjects. More importantly, for the last few years, she has been very much inclined and dedicated herself for the tech community, for I can say the scientific community. And yeah, with that, I would request Madam to just give us a brief startups on what are the challenges involved, or what I could say the process involved, the IP. Thank you.
Thank you so much for introducing me. And I have put together a PPT, and if there are any questions, I would be happy to take them as we are talking. I have been associated with the KSCST since 2019. I am a WIPO DL tutor, so this is my job, basically looking at intellectual property and how it can be used.
Your voice is not audible. I think you're on mute. You're on mute.
Am I
Yes,
audible now?
Yes, you're audible now.
So, okay, so what I said was, this is what I do for a living is all that I had said so far. I am a WIPO tutor. I teach people about intellectual property, and have been associated with the Karnataka State Council since 2019, and been associated with delineating invention capture, so to say, find out what projects are have patentable material in them, and then take it forward to prosecution. So what we are looking at today is where is the interface between intellectual property and startups, right? So the interface is in the intellectual property rights. If you have an intellectual property, there is some creativity, some creation that you have, which you need to protect, because it's not a tangible asset that you can wallet, right? So you need to have some kind of a right that gives you a feeling that it is protected. So what are those rights? Those are the rights, like patent rights for an invention, copyrights for something which is creative, like a dramatic or a play or things like that. Design are also protectable. Then somebody talked about GIs, traditional arts, those things are protectable under GIs. Now, all these things under the IPR framework, it gives legal protection, and there are enforcement mechanisms to safeguard these rights. So those are the laws. That is the Patent Act of 1970, the Copyright Act of 57, the Trademark Act of 99, and Designs Act. These all exist. Now, what we have to do is we have to make sure that that creativity under those laws protects those rights, right? So that what you have in the way of intellectual property is safe. Okay, so now what has happened, just as an example, in the United States, if you see, although intellectual property and patents specifically, this is about patents, all started in 1776, you can see that it is starting to really take off from 1975 to 2025, and especially here you see in the last 14 years, it's just going from 4 million to 5. Absolutely real steep slope. And that is all due to the patent filing. It's just aggressively filing. Okay. Now, what are the mechanisms? Now, we have been speaking about patents. Yes, patents could be at the core because you have an invention, you have to protect it, and patents protect that. But that is just the first layer. It's like an onion. That's why I have this onion over here. You have that at the core, and then you have other IPs which go like the layers of an onion, right? So patents, okay, let's start with patents. We have a national policy in which patents given a lot of importance, but there is, if it is a startup, needs to think big. Don't limit. What I would suggest is don't be myopic, don't limit your territory of protection to just India. Look big. There may be cost savings, if you look at the whole world. And for that, we are signatories to the Patent Cooperation Treaty, and that gives you a global advantage. How does it give you that advantage? You file an international application, and there is an international search report which provides an assessment of patentability. Okay, and it gives you a competitive edge. That edge, like it sort of puts you, because it's a different way. There are two ways of filing. One is the conventional application where you file a local office, and within 12 months you have to decide which countries you want protection, right? Patents are territorial in nature. You can protect your invention only in those countries where you are filing for the patent. If you file in India, you are not protected in Zimbabwe. Your material, your invention is laid open 18 months, it is published, it's in the database, and anybody in the world, if you have not protected it in that country, can make use or sell your invention. Okay, so what happens is you have filed only in India. So you are saying, or you're thinking, that your commercial interests are only in India. All right. And the patent, etymologically also, patent, the word patent is lay open. The opposite of latent. Latent means secretive. Patent means lay open. So you're laying it open, you're telling the world what you have, and you're asking for a deal with the government. And if you're filed in India, with the Indian government, that I'll tell you everything, you give me the protection. But that is limited to India. All right. So when you file a convention application, you're limiting your time. You have only 12 months in which you have to decide which other country you want to file in. Whereas if you go via the Patent Cooperation Treaty, you get much more time. You get 30 months to think about it, because you have, you file in India, in 12 months you file the PCT, then you get 30 months to decide which countries. Okay, and there are over 150 countries who are signatories to the Patent Cooperation Treaty. You can decide which countries you want to enter. Of course, once you enter those countries, the national laws reign supreme, right? The sovereignty of the national law is always, highest. You have to go by the rules, the patent laws of those countries, but in the international phase, you have already been assessed. So don't be myopic, and that's why I have taken just 3 of those WIPO advantages. One is the PCT, and the next is the Hague, and then the Madrid, the systems for design and trademarks. So those I will, just so that the startups have an idea, and you don't need to limit yourself to the Indian territory. Think big, think international, think broad.
Sirisha, sorry, you are on mute, I believe. Sorry.
Yeah.
Just now you want to.
Did you
Correct.
hear my PCT conversation?
Yes, yes, very much,
It
very
was
much.
great. It was great. Yeah.
Yeah,
Very
Okay.
last
informative.
10 seconds you got moved. You
Okay.
can
All
continue.
right. All right. So now this is about the Hague system, and this is for designs. This is also by the, it is administered by the WIPO. This is again an international way, a gateway to global opportunities, again, a way to expand your market reach, safeguard your designs, and get a competitive edge. So it is an ideal choice for Indian startups to protect your designs globally. Okay. And the same things, it will protect unauthorized use, unauthorized copying, and also, like, you don't want to limit yourself to India. You do it in India, it gets, it comes in a gazette, it comes in a magazine, but you've protected it only in India. Look at the global picture. You want to enter the international arena, so you need to protect it all over, right? In the short term, it might look like, it's a strain for you. Long term, it will be cost effective. So here is the second layer, right? The first layer was patent, second layer is the industrial designs. So all the layers that you are going to make around what is your innovation. Okay, so this is the second one. Let's go to the third one, which is trademark. And here also administered by the WIPO is the Madrid system. All right. Here also it gives international trademark protection. You go global, you enhance your market value, you safeguard this property right, but you have to understand the processes. Okay. Wherever you enter, those laws, they reign supreme. Of course, we can do an initial filing in India, whether it is patents, whether it is designs, whether it is trademarks. We can do the initial filings here. But when you take it, further than that, you need to understand what those territories, what those laws entail. Okay, now there is a little story about this company, CySecK. It's a Turkish company founded long, long ago, and they were famous. Turkey is famous for its coffee, and it was all merrily ambling along, where suddenly they decided to look at patent databases, and in August 2004, they saw that there is some opportunity for them there, and they launched a product which is they have a trademark for it, they have design applications for it, and patents for it. So they started with 8 international patent applications, 3 trademark applications, design applications, and they covered their entire technology. If you look on the side, you can see from 2004 to 2019, their product kept evolving with, in design and in functionality and everything. They kept moving with the times, and they kept filing. Okay, and for 10 years, they were the only people who had, it's almost like an exclusive hold over what they were providing, and they had a good, goodwill, they had trust, etc., etc. Now, right now, it has over 300 applications, and they have 75 patent families. Now, a family means, a patent family is this, you have a technology, you file it in one country, and then you enter another country because you see your commercial interest there as well. Now, that application in the other country becomes a family member. So technology wise, there are 75 technologies, but there are the 300 applications means each technology would have number of patents belonging to that same family, like that, and industrial designs, and trademarks, etc., etc. So it gives a huge strength to the company when they are entering other places, other countries, and it launches the product really well into the international arena. So now, just very quickly, to look at especially patents and what we have in India in the way of help or protection. Start the process, you begin drafting your application, you look at the invention, you see what is the novelty, industrial applicability, inventive step, etc., etc., and you start drafting, you file your application, and then you wait for the patent office to come back to you with a first examination report, and then you make a response, and then you again wait for the final thing. Now there are lots of time. You can see I've put 1 month, 2 months, 24 months, 2 months, 4 months. So it piles up. The time periods, and that is a loss in term. Time is money. It is going to cost you some way or the other. Now, what has happened now? We have as you all know, we have the Startup India initiative. There is a startup, there is stand up, there is digitize, etc., etc. And all of these, they are offering, lots of things, especially with respect to patents. There is fast track patent examination. There are reduced patent fees. There are many kinds of assistance, which I'm sure Nagarjun can give you details and documentation. The SIPP that he spoke about, the IPR awareness programs that we make from here, from the KSCST. All this is happening so that the startups, they don't have to put too much effort. Of course, we have to catch up. The world is moving at a very, very fast pace. But the effort in playing catch up is not going to be that bad because everything is facilitated, everything is made easy.
Yeah, yeah. Good, good.
Okay, so here, to look at what is the fast track examination. You see the picture on the left, all the steps I have put. You have to file an application, there is a request for examination, publication happens 18 months after that, then there is a reference by a controller to an examiner to examine that application, 6 months to 1 year for the first examination report. So these are the times which in the earliest slide I'd shown how, time. What has happened now with the fast track thing is this one, the 18 months period for publication and request for examination, all these things have been fast tracked. So you have a form 18A, you have to fill a fee, and a form 9 for converting if you already have, and the examiner has to reply. So basically, the applicant must respond to the FER, that is the first examination report, within 6 months from the date of the FER. That is the first examination report. So there is a time stipulated there, and the controller is also under an obligation to dispose the application within a period of 3 months from the date of receipt of the last reply to the first examination report, or a period of 3 months from the last date to put the application in order for grant. So these things shorten the time, right? So it's less of a strain on the startup. So this is a very, very important outcome of the Startup India initiatives. Also, we have patent facilitation centers. We pride ourselves in the KSCST in that we also do offer all these services here. We have, you get free legal assistance, guidance for patent filing, patent drafting, patent filing, and also for, the networking for commercialization. Okay, so we also have lots of training programs. If you have questions as to, like how to conduct a prior art search, how to answer a first examination report, how to draft the claims, we are there to help you. Okay, so then the next thing is, the buzzword is unicorns. We have lots of unicorns, right, coming up, sprouting. The thing is, the company is worth over $1 billion. Now, how is this all happening is something very interesting. So we have some stories here, just taken Flipkart as an example. So it started very, very small, very humbly, and they had 3 pillars, right? Flipkart Assured, Flipkart Quick, and it used artificial intelligence to figure out what the consumer needs are, and then accordingly modify their things, right? And they started their mergers, their acquisitions, and they grew big. Looking at their patent portfolio, if you look at how they were, you see from the year 2021, absolutely the Indian patent filing scenario is just skyrocketing. It just went up really, really fast. They looked at PCTs as well. And since they were interested only in the territory of India and perhaps whatever they thought in the neighborhood, the PCTs. So COVID perhaps, right? People didn't want to go to the market or whatever. They used that. That was the consumer need, and they capitalized on it. They monetized it. They made their intellectual property out of that need and converted it into money. You can see the patenting trend here. So it's basically a problem solving. There is a problem, and with patents, you prove that you're solving that problem and you make money out of that solution. And that's what you need to protect. And this is one of the unicorns we cite for that. The other one is Ola. Similarly, people need transport, and they have technology algorithms in the transportation sector. They also had their in 2021, there is a sudden spurt, and India is in the area where they're interested in. Their filings are maximum over here. So it's also something, if you want to see, it's a case study to see how a startup, really becomes a unicorn. Then one very interesting one was Byju's. It also, but one wouldn't expect it, but then it has a lot of mergers and acquisitions, files patents as think and learn, and also 2020 sudden surge in their patent portfolio. However, not in India, in United States of America, and others as well. So now I have a question for you if you're interested. So here is a product by a startup which has 7 components, right? The 7 components, and 5 components are covered by 2 patents which the startup has. The gray and the green are covered by its own patents. The red one here, the terracotta red, is in the public domain, and the pink one is covered by a third-party patent. But it needs all this technology to make its product. What should it do? It has 2 patents, which is the gray and the green. How will it go about it? Some food for thought. Think about it if you have any answers. Yes, please. I see a hand raised.
Yeah, hi, Sarah. Thanks for this question. I think we may have to seek legal advice or country-specific, region-specific clearance on that pink third-party patent. Only when that is clear, we can have the complete end-to-end offering in the market.
And also you will need to, you need to have the clearance. And if it is protected by a patent in your jurisdiction of interest, then you need to license it, exclusively or not. However, you need to come to a negotiation, you have to have a talk with them, decide on the monies, etc. And the public domain is, of course, not a problem. Thank you. Yeah, I hope that was of interest, of use to you all. Thank you for your hearing.
Yeah. Okay. Link. So thank you, madam. Thank you for showing a brief on what is the plight of the stages of different stages of filing, and what are the different challenges, and what are the things to do and don'ts, especially for a startup from a startup's perspective. Now I request Nagaraj to Nagarjuna to take up the next session on specific sections and specific areas where IP's interface can come up with startups, and also the other services offered by KSCST.
I think so. In the beginning itself, we have covered the services offered by KCST.
Nagarjun,
What I
your
look the
voice is
startups which
echoing.
are coming up with our issues. The first thing I see in the domain is that before coming to KCST or wherever either they go to IP firms or whatever it is. Okay, so few startups, they publish their the product or the patent, anything. Okay, so initially they'll show the product to someone else, somebody. Okay, and later they file. In the FER, the first and foremost objection will be their prior art only. Okay, so this the startups has to be noted, and before going for any kind of protection, they should not publish their invention anywhere, even as a small advertisement in a Facebook or WhatsApp. that's also become sometimes a prior art, and the objections will be there to grant a patent. Okay, and however, there is a separate section for that, where there will be a time period where it can be accepted, but the better we should not take chance in the particularly with respect to any kind of industry oriented instruments or inventions. Okay, and the second problem with the startups, especially with the trademarks concern. Okay, nowadays, because we have seen a trademark will be examined for 3-4 years, they are taking much time. Okay, and however, we have seen within 6 months also you can get a trademark. At least minimum 6 months is the time that you can get a trademark. Okay, so in between, lot of because of this, the government like jump portal, okay, is to apply for some kind of tenders. Okay, so there is a mandate that you need a trademark compulsory. The registration of trademark is compulsory. Okay, so in this context, lot of people are approaching KCST for trademark filing. Okay, so we are also doing our best, but however, we also feel that the time limits have been not met with respect to the filings from the both the ends, like even from the client or from cases, even from the patent office also. Okay, so that has, patent office has been taking care of that to fast track the applications. It is in the pipeline. Hopefully, the problem will be solved in the short period, I believe. Okay, so this is one of the second observation with respect to startups. Okay, and another important aspect is that initially the startups will go for a protection, okay, due to the cost of orientation, whether because generally to file a patent it may cost about 1 lakh rupees with respect to the professional firms. Okay, so we advise, we have a similar kind of services here also, that we inform the startups whether is there any kind of commercial returns out of it. Okay, so if you really feel that there is a commercial returns out of it, then we advise to go with a firm or a agent, because the protection is important. And parallelly, since you have been dealing in the practical market. Okay, so in future there may be some kind of infringement will happen, definitely. Okay, so initially the cost burden will be there, we agree, but however, you need to utilize the facilities like the startup funds from the PIC for supported funds from the startup Karnataka, and MSME also we have some schemes, and shortly KCST is also been associating with the patent office for under SIPP scheme, where 25,000 of professional fees for the patent filing will be taken care by the patent office. Okay, so timely services will be provided. We have been shortly we will be nominating some of the patent agents at KCST for this kind of facility. Okay, so that you can utilize where you no need to pay the professional fees, just government fees you have to pay. Like for patent, 1,750 rupees is the government fees, and trademarks 5,000 or 10,000 will be the fees, and for copyright 500 or 2,000, designs 1,000 rupees or 2,000 rupees. So this is the government fees which you need to take care startups, and the rest professional fees will be bear by the facilitators directly from the patent office. Okay, so these are the major three issues which concern with the startups, and even maybe we can associate to any industries as well. Okay, so with this, we can take any issues with respect to filing or some kind of issues which has been in the pipeline with the startups, whether they're unable to process their application or anything. Direct questions are there. Maybe we can address on case-to-case basis now. Anyhow, our Sarasija madam is also there. Maybe she can also put throw some inputs on that.
Right. If any question, the floor is open for questions now. So any questions, please open up. If you have, yeah, Jerome.
Thank you so much for this insightful session. My question is regarding trademarks, specifically for names and logos. If you could throw some light on the process and the benefits and the disadvantages in general, but just the overall process on trademarks of names and logos would be really helpful.
So basically, trademark also you need to go first prior art search. Okay, so we have the standard search databases. Basically, we go with Indian database only. Okay, so it's easy in the sense there is a direct, we can just search ourselves itself. Okay, uh, and another important aspect with respect to trademarks is that basically the companies or the startups, what they are doing the business, they name the trademark with respect to their business. For example, you take, if a hotel business is there, they'll keep Idli Hotel or some name associated with Idli. Okay, so like this, they are planning for the trademarks. and they'll file for trademarks. Okay, but in the trademark registry, okay, they particularly says that if you want a good trademark, okay, it should not indicate the business what you are doing it. For example, if you take Amazon is a company, but Amazon basically a forest, but forest doesn't direct relate to the Amazon company what we have. So like this, the trademark should be selected first. Okay, so these kind of trademarks, I mean,
But why
generally
why
the
is there any specific reason you are saying that, Mr. Nagarjuna? There should be no correlation.
not because directly the company name, I mean, there are some set of criteria for selection of a trademark. Okay, so these trademarks comes under fanciful trademarks. Okay, uh, if trademark, if it's fanciful, then obviously the priority of getting it granted is high. Okay, so that's why we advise to go like this. Even if you have the name, it's okay, it will come. Okay, but most of the times the chances of rejections will be there. That's what. Okay, so this is one thing. And other, basically the process is very simple. So once you file for startups, it's 5,000 rupees is the fees, government fees, and professional fees maybe 5,000 to 15,000. And even for trademark, I mean, it depends upon the company also. Okay, so for big companies, maybe they charge about 1 lakh to 5 lakhs also for registration of one trademark. Okay, it is like that. Okay, so but basically 5,000 is the basic fees that you can just afford, and you can file the trademark. And other important aspect with respect to trademarks, I believe, and it's better even in the beginning itself, you need to register the trademark. Okay, whether it's granting or rejecting, you don't worry about that. Okay, but however, you need to file application. That's very important. Even though gradually the controllers also advise you can change or you can amend the trademark if it is required. They'll also give some chance as to change it. Okay, so that's why it's better to take, I mean, file the trademarks.
Thank you. And another quick question as a follow-up. Once
Yeah.
you kind of register, are you able to use that particular name, or do you wait until it's kind of confirmed by the government?
No need, no need. So once you file the trademark, just put a TM symbol and use it. Okay, don't wait for the register to be granted. Okay, so even it is not granted, also no worries, because the IPs doesn't infect on the process of business. Okay, so once we need to start the business, to safeguard our business, IP is required. Okay, so like that, this is a simple strategy. That's all. So you just see if protection of IP is worthwhile for you, so that you can get some returns or you can stop others for infringing, then you do it. Okay, so if there is no returns out of it, probably you can take a chance to leave it also, because trademark registration is not mandatory for you. Okay, yes.
Thank
I
you so
think
much.
there's a question from Professor Gaurav. Yeah, Professor, can you please?
Yes, thank you, Shivling. So first of all, thank you so much for such an informative session. I really appreciate all the details that you've shared with us. I actually have three questions. I'll just shamelessly ask all three of them, but
Yes, please.
I'll just group them. One of them is a procedural question. Will it be possible for Shivling, your organization, or the Karnataka government organization, come up with a small sheet, maybe 1 or 2 pages of information about how we can tap into these various government schemes where the professional fees are either fully or partially waived, and like one was mentioned, I understand there are a few. So, for Karnataka registered startups, right, how we can tap into these schemes, if there can be information sheet, right,
Sure.
that would really be helpful. I have two
Agreed.
technical questions, for Sarasija ma'am. And again, thank you so much for such an informational session. So I think my first question, and these are both technical questions. The first one is, you mentioned there can be multiple geographies. So if we are looking at that market, then we should file a patent to protect ourselves in that market. Suppose, just for the sake of example, that we file a patent in India, because of course our market is here. We also file a patent in the US, taking derivation from PCT and so on. Now, suppose our Indian patent gets accepted, the US patent gets rejected, right? So can somebody with a similar patent in the US, suppose it gets rejected on the basis of prior art or something like that, and they sue us in India, for our product, which is now patented and protected by an Indian patent.
No, like this. when you file for a patent, right, the examiners examine it for novelty, inventive step, and industrial applicability, depending on what resources are available to them. Okay, now in the Indian community or in the US, something might be in public use. Or it might not be documented, it might be just known. So that information is available to that examiner on the basis of which he says this patent cannot be granted or has to be amended or whatever. However, in the Indian context, you have filed in India first and you've been granted a patent in India first. The laws of India afford you protection over here.
Thank you. I mean, that's very reassuring.
That is the deal you make with the Indian government. If you've been granted a patent, that means the Indian Patent Office sees your patent or your technology as novel, industrially applicable, and inventive. The Indian Patent Office has examined it and come to the conclusion that it is patentable, and it is given you and it affords you protection. There is no question of this thing. However, now the flip side, of pharmaceutical companies, right? They patent their drugs, let us say in Europe, and then they enter the Indian market. They have a patent granted in the European whatever country. When they enter India, the Indian government deems
There is some wonderful connection. Wait till
right? It's published 18 months after the filing. You can make, use, or sell, but you cannot patent it again. You can't file for a patent because the novelty doesn't exist. The information exists, and that information can be used.
Okay. Thank you. Yeah, so you dropped in the middle, so I didn't get the whole thing.
Dr. Banerjee?
Yes. Can you hear me?
Dr. Banerjee, I can hear you. I guess Sarasija Madam is not able to hear us. Sarasija, can you hear us? In fact, Nagarjuna, can you hear us?
I can hear you.
Yeah, madam. Yeah. So, see, there was a drop in your voice, so we could hear you till the example. You begin the example of a pharmaceutical company. So, if you could just come back on that.
So what I was saying was, see, in Europe, let us say a pharmaceutical company files for a patent, and a while later it files for the same technology in India. In Europe, it gets granted, but in India, it is not granted. The examiners deem it unfit for a patent. Okay. Now, after the patent is published in the European patent gazettes or in the patent office databases, that information is already in the public domain. Anybody in India can make, use, or sell that technology, but they cannot patent it. The novelty is not there for a patent to be filed. But since the technology is available, it is not protected in India. The technology is to go ahead and make use of it, they can. That is an invention already in the public domain.
I'm sorry to interrupt you. There is some network fluctuation. So, can you just put off your video?
Hello, so I have lost everybody.
Can you hear me?
Yes, yes. Ms. Sarasija, I request you to put off your video so that.
Was that clear?
Yes, yes. It was quite clear, but I request you to put off the video for some time so that the voice is more reachable.
Yes. So thank you. I'll just ask my last question real quick,
Sure,
since you mentioned publication. And this is actually, coming from the other hat that I wear because I'm a faculty member. Suppose me and a student, we come up with a new idea. And as you know, in academia, survival, students need to publish, right? And so, and when the patent application is pending, there is a certain period for which they cannot publish. I'd very much like them to do, to continue with their PhDs and so on. So how much time do we have? Suppose, we file an Indian provisional patent. Typically, how much time do we have before we can publish it? So that, the patent is protected, The student is not adversely affected.
You have 12 months before which you have to. Provisional patent is not published. 12 months you have to file the complete specification, and in 18 months after that, subsequent to the complete specification, it will be published by the patent office.
But suppose we want to publish that idea now in a journal, right? In an open journal, because of the academic requirement of the student. What is a milestone? Does the fact that we have filed a provisional patent now allow us to lock it in and then publish
Yes, it
it in a
does.
journal?
Absolutely does. That is the main purpose of a provisional application, is that you define your metes and bounds, you define your turf, that is your territory. Anybody stepping on it is trespassing. So you do the provisional application basically to say, this is mine. You can go ahead and do your article. That doesn't, that's absolutely safe. That's the strategy we also advise.
Thank you. Thank you so much. That clarifies things a lot.
No problem at all. My pleasure.
Any other questions? Last one question, we can definitely take it up. We have another 5 minutes to go. And
maybe with respect to trademarks, okay, if anybody has a doubt with respect to whether it is got registered or not, you can send you a picture or the trademark to KSCST, like PIC. We conduct prior art search and we give you the report, like the similar kind of marks available in the public domain or not. We will do it and we will help you to do that. Okay. Yes.
Definitely. Thank you, Nagarajan. In fact, that also, one commitment on us, as Professor Gaurav also had requested. Later to this session, me and Nagarajan will sit together and try to compile all the teams and services which are offered. And there are the funding support schemes which are offered by Government of Karnataka for the startups, and we'll be sharing it. It will require a day or two to finalize, and we'll definitely share it.
Maybe we can get as informed by the one of the startups. Okay, so we can make a bulletin and we can make the nodal point of contacts so that they can directly access their numbers, because many of the times the details will be there, but to whom to approach, exact contact details won't be available. So probably we can just figure out with all the departments, and we'll make a narrow it, and we will. We will do it properly, and we'll publish it in the public domain so that they can get the proper benefits. Yes.
Wonderful. Thank you so much, Mr. Sarasija and Nagarjuna, especially because for taking out time. They're actually busy with a 5-day workshop at GKVK campus. There's an in-person 1-week session going on, but because of our request, they had come out and dedicated their time for us. So for the benefit of startups, I'm sure it was helpful. It was indeed at least enlightening, because there are many things to be followed up, and we'll definitely open up on that. And with that, I request all the startups to start taking benefits of what are the existing schemes and benefits are already available. For say KSSTs within the location of IISc, within the campus of IISc, Indian Institute of Science, Bangalore. So next time we are at our CySecK office, I'll definitely have take you a walkthrough to PCell or PIC, and make you walk through the different schemes and services they are already having. And apart from that, also feel free to have any questions, outreach them through mail or phone. Sure, Abhishek, I have heard you. I read your message. Definitely will put up that white paper and share it to ASAP. And yeah, with that, thank you very much once again for KSCST's PIC for bringing this out and throwing light on us, throwing light on the IPs and patents, the pathway to that. Thank you very much. All the participants also for making out time, pouring out your questions, making it a very vibrant session all over. Thank you.
Thank you.
Thank you.
Thank you, audience. Yes.
And lastly, I would say that our first session was for the core startups, especially. The last session was on funding and valuation. This was on IP. These both were outward seeing sessions. The next session should be more on inward session, where we try to help startups on building enterprises networks, where working with sales, encouraging more enterprise sales and all that part. So very shortly we'll be announcing you the next set of mentoring sessions also with more details. So stay tuned, I would say. Thank you so much.
Thank you.